And what I'm asking for in this motion is for the defendant, through her counsel, to actually provide any admissible or relevant evidence that pertains to third-party culprit, which to this point they have not done. So if this is something that's going to be raised as an issue on its own, as the court is well aware, what the case law indicates is that the acts of the other person are so closely connected in point of time and method of operation as to cast doubt upon the identification of the defendant as a person who committed the crime. It has to be specific. It has to be to at least a specific realm of person or a specifically identified person who would have motive, opportunity to commit the act with which the defendant is charged.
So the initial question is, why is there a third-party culprit defense? Why is it relevant? And we start, Your Honor, with the fact that our forensic medical examiner, Frank Sheridan, a pathologist, forensic pathologist who has performed himself thousands and thousands of autopsies, has already submitted a sworn affidavit to this court that John O'Keefe's injuries are consistent with having been in a fight and are not consistent with having been hit by a car. Since he submitted that affidavit, the federal authorities have provided us with their reports, whereby FBI experts also corroborate that John O'Keefe's injuries are not consistent with having been hit by a car. They employed experts in biomechanics and kinematics who have reviewed the evidence in this case, and they've confirmed that the physical evidence essentially shows and doesn't show what Dr. Sheridan has opined. So therefore, if John O'Keefe was not hit by a car, that means that Karen Reed did not kill him. And we know that John O'Keefe did not die of natural causes. This was not a heart attack or a stroke. John O'Keefe was injured. He was mortally injured. If he was not hit by a car, as both our expert and FBI confirmed, then he was attacked. And if he was not hit by a car, then there is a third-party culprit or culprits. So by asking this court to prohibit the defense from introducing evidence that others had the motive, opportunity, and the means to attack John O'Keefe, the Commonwealth is essentially asking this court to prohibit Karen Reed from being able to defend herself.
So I don't think they're asking that you be prohibited from doing that. They're asking first to have you tell them what that is.
Right. Well, this is, Your Honor, I'm getting to that in terms of
All right, so go ahead. You have your remarks.
That we're either required to give them or not. It is not our job to solve this case for the prosecution. It's our contention. They had the opportunity to do that, but they failed. It is not our job to name a specific third-party culprit. We do not have to prove that Brian Albert or Colin Albert or Brian Higgins or some combination of them intended to kill John O'Keefe. We don't have to prove that any of them attacked John O'Keefe such that he eventually died. They have to prove beyond a reasonable doubt that they didn't. But the fact of the matter is there is evidence that all three of them had a motive, had the opportunity and the means to attack John O'Keefe. Now, the Commonwealth cites Commonwealth versus Conkey in their motion, and as this court started the discussion on this issue when you first took the bench, Conkey makes clear that a defendant has a constitutional right to argue that somebody else may have committed the crime. And certainly, no, the acts of that person can't be too attenuated in time or method of operation, as Mr. Lally mentions. But in terms of being the right time period, Your Honor, you can't get any closer than their presence at the scene at the very time that John O'Keefe was killed. And in terms of the method of operation, given that we have evidence that he was not hit by a car and that he was attacked, all three of these men, either alone or in combination, possessed the ability to attack him with or without a weapon. I mean, it's a very low standard here. The Commonwealth acknowledges that. It's a low standard of simple relevance. And the evidence here establishes relevance. Now, I would note, Your Honor, the Commonwealth cites Commonwealth versus Finney. I don't know if they realize this, but that was my case. I represented Roland Douglas Finney before the Supreme Judicial Court, and I represented him at his motion for new trial and at his retrial. And that case, the Finney case, provides strong support for the introduction of third-party culprit evidence here, irrespective of a Bowden defense. In fact, the reason that Mr. Finney's conviction was overturned was that his trial counsel failed to pursue a third-party culprit defense. And Your Honor, the third-party culprit defense in Finney was weaker, far weaker than the third-party culprit defense we have here. The evidence of motive in that case was that the third-party culprit made derogatory statements about the victim after she was murdered. No witness in that case put the two of them together. No witness in that case put the third-party culprit at the scene of the murder where the victim was murdered. There was some consciousness of guilt evidence similar to what we have in this case. But in Finney, the SJC ruled that not only was that enough for a defense attorney to present a third-party culprit defense, but he was ineffective for not doing so. And as the court has also touched upon, the SJC found that on the basis of that third-party culprit evidence, which is weaker than what we have here, there were substantial connecting links between that third-party culprit that justified the admission of hearsay in that case. And I want to make it clear, we're not looking to introduce any hearsay statements, so we don't need substantial connecting links here. Now, Your Honor, I could go through with the court the specific evidence we have with regard to motive, opportunity, and means with regard to the three Commonwealth witnesses that I've named.
So go ahead.
Happy to do it. Starting with Brian Higgins. He was present at 34 Fairview Road on January 28th to 29th. He was close friends with the homeowner, Brian Albert. He had a prior romantic interest in Karen Reed. He did not expect Karen and John O'Keefe to be at the Waterfall, that bar, on January 28th. Karen Reed did not greet Higgins, despite the fact that they had previously exchanged flirtatious texts and that she had been at his apartment one evening, although there was nothing that took place between them any more than a peck of a kiss. At the Waterfall, Higgins does not engage with John O'Keefe. He does not say goodbye to John O'Keefe and Karen when he leaves, but before he leaves, he texts Karen, and that text was something to the effect of, well, with a lot of M's. We know that there was a preservation order from this court, your predecessor, Judge Krupp, to preserve his cell phone, and that Trooper Proctor gave him an edict, an order to serve on Brian Higgins, and he left it at the front desk of the Canton Police Station for him, and that Higgins, we learned through the federal investigation, Higgins became angry, demanded that Proctor come back, and he essentially upbraided him and read him the riot act, which shows a little bit about Higgins' personality. At the end of the night, everyone discussed going back to 34 Fairview, and when he gets back to 34 Fairview, he texts not Karen, he texts John O'Keefe at 12:20 a.m. He testified before the federal grand jury that he had no knowledge that they had been invited to 34 Fairview, but that is contradicted by this text message. And the inference is that he was coaxing John to come to that house. And, you know, we're not saying this gives him a motive to kill John, but we don't have to show that. Any motive to feel hostility or animosity towards John O'Keefe goes to his motive. And Your Honor, when Brian Higgins and Brian Albert are in that house, they're the only two people who are unaccounted for when the rest of the group was in the kitchen. And they claimed that they were looking at photographs together. And we have evidence that they were in the basement. We believe that Brian Albert made a mistake before the state grand jury by testifying they went upstairs to look at photos. Brian Higgins says unequivocally that the only place the two went was into the living room to look at photos and military ribbons, whatever they were looking at. Brian Higgins did not know that Brian Albert had said they went upstairs. And he also testified he had never been upstairs at Brian Albert's house in his life. That means that if Brian Albert said they went upstairs, they're coming up from the basement. And before leaving 34 Fairview, Brian Higgins testified he was parked right in front of the mailbox. He would have had to have walked by where John O'Keefe's body was. His headlights, when he got in his vehicle, would have been illuminating where John O'Keefe's body would have been in the yard if it were actually there. So how does he not see it? He then goes back to the Canton Police Station at 1:30 in the morning after leaving 34 Fairview. He claimed to do some administrative work, but then he admitted to the federal grand jury that he was there to move his car because of the upcoming snowstorm. This suggests that he was fabricating a reason for going back to Canton Police to establish an alibi for himself. He was asked several times at the federal grand jury if he had any conversations with anyone before he went to bed. And when was he notified that John O'Keefe was dead? In the morning, he said. He testified under the pains and penalties of perjury that he had absolutely no contact with any person that night for any reason whatsoever. But he apparently was surprised that the federal authorities had subpoenaed his phone records, and he had to admit, and he did admit under oath, he made that 2:22 a.m. phone call around the same, about 5 minutes before Jennifer McCabe is Googling how long to die in the cold, about 8 minutes before Brian Loughran, the plow driver, first drives by the house and sees no body at all. And the next morning, Brian Higgins, the first person he spoke to was Brian Albert.
I'm going to stop you for a minute. I think we need a break, Madam Court Reporter. Do you need a break? Can you go? How much longer do you think you have with this, Mr. Yannetti? How many more pages or how long you think?
Yeah, I've got about, in terms of my recitation of the facts, I've done about a page and a half and I've got 3 left.
Madam Court Reporter, would you like to take a little break? It's hot in here and you've been going nonstop. Okay, let's take a 10-minute break. All right, Mr. Yannetti, go right ahead.
Thank you. Your Honor, I left off with the morning of January 29th. The first person that Brian Higgins spoke to was Brian Albert. He had missed a call from Chief Kenneth Berkowitz earlier. Immediately after getting off the phone with Brian Albert, Brian Higgins drives back to 34 Fairview, where he has a meeting with just about all the witnesses in this case: Brian Albert, Julie Albert, Jennifer McCabe, Matthew McCabe. And immediately after that friends and family meeting, on his day off, which is a Saturday, he returns to the Canton Police Department, where he speaks with all of the first responding officers who had anything to do with this case. So this is a quote unquote witness accessing and communicating with all the first responding officers, we would argue monitoring what they're doing in regard to the investigation. According to Brian Higgins, he admitted that Chief Berkowitz is one of his best friends, and that's why he had access to all these people. We have a law enforcement witness who will testify to seeing Chief Kenneth Berkowitz and Brian Higgins alone with Karen Reed's vehicle on the afternoon of January 29th of 2022 for, quote, a wildly long time.
So is this a name that's been in the materials? Is this a name known to the Commonwealth? Or
Yes.
Is this somebody new? Okay.
We've now received video surveillance from the Canton Police Department that shows that there is an interior camera in the Sallyport garage where the car was housed. But during the exact time that third-party officer indicates that Berkowitz and Higgins were in the Sallyport together, the video mysteriously cuts out for 42 minutes. Between 5:08 and 5:50 p.m. And just to be clear here, we never get to see the condition of the taillight when it's brought into the garage. When we do see the car, we see it after Brian Higgins, Chief Berkowitz, Michael Proctor, and Yuri Buchnick have all had access to it. At 5:36 p.m., the car pings that it's arrived in the Sallyport That's during the missing video. Trooper Proctor, Trooper Buchnick never sees Brian Higgins' phone. They speak with him, and he takes it upon himself to use his own resources, Brian Higgins, within the federal government to ask a friend, Special Agent Matt Kelch, to download only the text messages in his phone between Karen and him and John. And that's it. We have to take his word for it that we got all of them. And we certainly don't have any communications between him and Brian Albert, for instance. On February 10th, when he shows up to his interview with Troopers Buchnick and Proctor, he brings with him copies of the text that he has deemed relevant in their murder investigation. And he hands them the copies of the extraction that he had his friend do. He then calls Matt Kelch the weekend of this incident to do the limited extraction. He never tells Trooper Buchnick or Trooper Proctor how he extracted the tests, despite the fact that it was done by a friend of his in the federal government. During the federal proffer, Brian Higgins admits that he had been served with a preservation order, and the Commonwealth told him he could destroy his phone despite the order. He then drives to a military base on Cape Cod, opens his phone, breaks the SIM card, and throws the phone away. And he says that he discussed destroying his phone with Brian Albert. Brian Albert also destroyed his phone. And Brian Albert said that he had received some text that concerns him as an explanation. And after that, Brian Higgins changes his phone number and changes his cell carrier. In short, he was present that night, he had a motive, and there is plenty of consciousness of guilt cover-up evidence with regard to Mr. Higgins. Moving on to Colin Albert. Shortly before January 29th of 2022, Colin Albert lived with his parents, Christopher Albert and Julie Albert, on John O'Keefe's street, just 2 doors down. We have evidence of bad blood between Colin Albert and John O'Keefe. We have evidence.
How old was Colin Albert at that time?
I believe he was 16 at that time.
Okay.
We have evidence that Colin Albert and John O'Keefe used to get in confrontations because Colin Albert used to cut through his yard without permission, and John O'Keefe was not happy about that. We have evidence that Colin Albert used to throw beer cans intentionally into John O'Keefe's bushes, and John O'Keefe was not happy about that. We have evidence that Christopher and Julie Albert knew of this conflict. We have evidence that they referred to John O'Keefe as Nebercracker. That's a character from I think a kid's movie, who was known as the get off my lawn guy. When John O'Keefe and Karen Reed were vacationing in Aruba over New Year's Eve 2022, the Alberts, Christopher and Julie, taunted him. They went to his porch and they had photos taken of themselves drinking on John's property when he wasn't there to do anything about it, evidencing they knew how upset he was at what Colin Albert had been doing. Now, the investigators in this case, Your Honor, including Michael Proctor, kept Colin Albert's name completely out of the police report. When this case began, I had no idea who Colin Albert was. I received a tip right from the jump that Brian Albert and his nephew had beaten up John O'Keefe. I didn't even know Brian Albert had a nephew at that time. But after receiving the tip, I learned of the conflict that Colin Albert had with John O'Keefe, so I sent a letter to Mr. Lally, I believe by certified mail. I knew that the DA's office was planning to present evidence or witnesses to a grand jury, and at that early juncture, before anybody had asked them to indict, I notified the DA of 3 potential suspects, the ones that I'm talking about now: Brian Higgins, Brian Albert, and Colin Albert. After he received that letter at our next court appearance, I'm sure Mr. Lally can confirm this, he acknowledged that both Brian Albert and Brian Higgins would be testifying or had testified before the grand jury, but he questioned why I included Colin Albert in my letter. He told me at the time that he had no evidence that Colin Albert was there that night. However, after receiving my letter, lo and behold, multiple witnesses testified that Colin Albert was at 34 Fairview the night of January 28th to 29th. And now the DA will argue, I'm sure, at trial, that he left before John O'Keefe arrived, we don't find their evidence compelling. We don't accept it. We are not required to accept their theory of the case. We're entitled to present a defense. His presence at 34 Fairview gave him the opportunity, along with the motive, to harm John O'Keefe. With regard to Brian Albert, Your Honor, this is a well-connected, well-known, powerful family in the town of Canton, Massachusetts. Brian Albert was present at that home when Colin Albert was there. Colin Albert is a member of the Albert family. He's nephew of Brian Albert. We have evidence that Brian Albert had expressed hostility toward John O'Keefe as well. And we know that he initiated a phone call with Brian Higgins at 2:22 in the morning. He reached out to Brian Higgins. And then he picked up the phone when Brian Higgins came back, and they spoke for 22 seconds. And they never revealed any of that to investigators. Again, consciousness of guilt. And perhaps most of all, Brian Albert is a first responder. He is duty bound to help somebody who's in trouble. He was notified that John O'Keefe was in trouble. Brian Albert stayed in his home. He knew what was going on outside. His sister-in-law was out there, civilians, medical personnel eventually arrived. He did nothing. That is also consciousness of guilt. Now, Your Honor, with regard to all of that third-party culprit evidence, to admit it substantively, which I would assert to the court is both overwhelming and powerful. With regard to the Bowden argument here, the police investigated none of that. That didn't come from the Commonwealth. They had a complete lack of curiosity as to what was going on in that house that night. They didn't care. Investigators never went in. The feds investigated, and that's where we got a majority of this evidence. So, to the extent that the Commonwealth now claims that they didn't have notice of this, I beg to defer. They got notice of this when we got notice of this. The Finney case, Your Honor, again, I'm well familiar with it. It stood for the proposition that, if you want to point the finger at a third-party culprit, you've got a constitutional right to do that. And if you want to point out inadequacies in a police investigation, you have a constitutional right to do that. Right? It's for those reasons that I ask you to deny the Commonwealth's motions.
Okay, thank you. Any response, Mr. Lally?
Briefly, Your Honor. Just first, again, what the case law requires is evidence and not just mere speculation, or saying that you have evidence is not actually evidence. I do find it somewhat interesting that Mr. Yannetti wrote apparently 4.5 pages of notes, but didn't have time to write a motion to admit the evidence that he claims that he has. He references in regard to third-party culprit, Dr. Sheridan, who indicated that the injuries are consistent with the fight. He's the same doctor who indicated that the injuries on Mr. O'Keefe's arm were consistent with the dog bite, which was then refuted by the DNA findings from UC Davis, as well as the fact that the injuries are only on one side of the arm. And last time I checked, dogs have teeth on the top and the bottom, and there's no injuries to the bottom of Mr. O'Keefe's arm. Furthermore, the counsel references the federal grand jury materials in which I would say, as has been done numerous times previously, is severely mischaracterized as to what they actually contain. And it's not a crash reconstructionist as it's been alleged here before, it's a biomechanical engineer. And essentially what they did was take painstaking lengths to determine that the defendant's vehicle did not strike Mr. O'Keefe in the back of the head, which is simply something that no one has ever said, intimated at any point ever. there is also a medical examiner in the federal materials who concurs completely with Dr. Scortibello's findings as it pertains to the cause and manner of death. So with regard to each of these, the other thing that I would point out is counsel was counsel record with the Finney case. The Finney case relates to third-party culprit under the Bowden event. So it's not applicable to what counsel was arguing. It is a low standard, but it's also one that the defendant here has not met. It's not one without limits. As it pertains to much of the material that it was summarized as far as speculation as to what different things counsel feels mean from various things regarding Mr. Higgins, Colin Albert, and Brian Albert, just starting with Colin Albert because that's frankly the easiest. He wasn't at the house, and that's what the federal materials confirm with each of every single of the witnesses that were spoken to by the district attorney's office or the troopers or testified to the state grand jury. They testified to the exact same things in the federal grand jury, that Colin Albert had left the house prior to the defendant and the victim arriving there, and there's absolutely nothing to combat that whatsoever, other than, again, just rank speculation. So opportunity would be a little bit amiss if he's not even there at the same time as Mr. O'Keefe, regardless of the invalidity of any sort of ill feelings or ongoing feud that's purported from whatever unknown evidence counsel claims to have. In regard to Mr. Higgins, that was a fanciful story, but again, there's actually no actual evidence of most of those things, or at least the imputations or the connotations the counsel wants to put behind that. Whatever he feels things were observed. So again, I'm not sure where the evidence from this is coming from. What I'm also a little confused in regard to is that if counsel is merely relying on materials within the federal grand jury and just learned of them at that same time as we learned of them when materials were provided pursuant to TUI, then it's a little peculiar that the exact same arguments were being made throughout the pendency of the case well before counsel was provided with any of those federal materials.